Thanks for joining us, Dale.
Thanks for having
me. What would
me.
you say are the big takeaways regarding what do we know about his record? Is it good, bad, points of concern?
I think it's great. The opinions that we've reviewed, that where he's ruled on immigration issues, have all been America First type opinions. He's ruled in favor of the American worker. He's concerned about Americans being displaced by foreign labor. He's concerned about American business. And he's also very concerned about importing guest workers and replacing Americans who otherwise could do those jobs.
So, in a nutshell, would you say his judicial philosophy is to give deference to Congress, or is he an activist judge to rewrite the immigration law?
He is absolutely an originalist. He interprets statutes as written. He follows his view of the Constitution is that it needs to be followed and that judges are not to make policy.
So in this one case where they filed a relevant dissent, Chow versus Department of Homeland Security, this was a case involving a Brazilian restaurant that was making the claim, listen closely, American workers cannot learn to cook Brazilian-style steak. Putting it over a grill, cooking it over a spit, serving it and slicing it in a particular way requires the importation of foreign workers. In fact, this has been going on for some time. Are you familiar at all with this case?
Yes, absolutely.
So this was an L case, right?
Yes, it was.
So they were bringing in these people cooking steak under the visa called L.
Right.
Tell us a little bit about what that is.
Well, that visa is for people with specialized knowledge and skills. So what Fogo de Chao was saying was, we have to import a chef to cook in our restaurant. An American can't do this. This requires some special skill that an American could not learn.
Right, but I thought the L visa, okay, we're not talking H-1B now. This is the L visa. Is for intra-company transferees, managers, executives. The idea behind L was for, say, a multinational to transfer a senior executive from, say, BlackRock to do work here who possesses specialized knowledge to work temporarily on a project for that company.
Correct.
Did Congress intend for garden variety, admittedly specialized chefs to be considered L visa holders?
Absolutely not.
And so how long had this been going on?
Oh, this has been going on for quite some time.
Years, right?
Years, absolutely, years. And finally, this case worked its way up through the courts into the D.C. Circuit. And,
but it started because the BIA, the Board of Immigration Appeal, the Department of Labor, said this is not a proper use of L visas,
correct.
Right?
Correct. Yes.
The D.C. lower district federal district court said yes, it is.
Yes.
Appellate court, the majority opinion said remanded the case.
Correct.
Opposed the government, right?
That is correct.
And Kavanaugh filed the dissent. Now, this is the reason we're talking about this. Kavanaugh took a look at this, and what did he say?
He actually looked beneath what Fogo de Chao was doing and said, what you're trying to do is just import cheap labor, okay? To say that Americans can't be trained to cook Brazilian meats is absurd. So specifically, he said, mere economic expediency does not authorize an employer to displace American workers for foreign workers. Excellent holding. Sadly, he was the dissenter, so that's not the rule.
The material point is he's looking at the original statute, what Congress intended,
correct,
and applying the law as Congress intended to protect American workers.
That's correct.
That's Brett Kavanaugh. What else do we know about him?
He's ruled in a couple of other cases. There was a case where illegal aliens had voted in a union election, and that was challenged.
The Democratic Party loves this idea.
Yes,
right?
correct.
Illegal aliens voting in union elections.
Yes, yes. And in that case, once again, Judge Kavanaugh, or the majority, upheld the election, and Judge Kavanaugh again dissented and said that.
And what did he say?
He cited to IRCA, the 1996 law passed by Congress.
Now, IRCA was passed in 86.
Excuse me, 86, that prohibited employers from hiring illegal aliens. So he thus reasoned that the National Labor Relations Act could not possibly apply to illegal aliens, and that election should have been voided.
So Judge Kavanaugh is applying the immigration law in a way that would make it harmonious with the rest of the federal law, statutory scheme,
Right.
so that it all makes sense and hangs together.
Correct.
So that if someone's here illegally, that obviously means they don't benefit from certain elements of union labor law.
Exactly.
Wow.
Yes.
Okay. That's fabulous stuff, right? That's the kind of stuff we like to hear. Somebody who's applying the congressional intent and making it synthesize with the rest of federal laws. Okay. Anything else?
Yeah, there was actually a 2014 opinion that Judge Kavanaugh wrote. He actually wrote a concurrence in this case. And what was being challenged there was the requirement, the U.S. government requirement that products contain a label that says "Made in China," "Made in the USA," "Made in Germany," so that consumers could choose to buy American. Well, not surprisingly, many conservatives actually voted against this rule, saying, it harms commerce and it violates free speech and whatnot. Judge Kavanaugh in the case filed a concurring opinion, and he found that there was a substantial government interest in protecting American manufacturers, farmers, and workers.
So Judge Kavanaugh wants to protect American manufacturers, farmers, workers, wants to protect American workers from unfair competition from foreign workers, and he wants to make sure there's proper synthesis that allows the primacy of federal immigration law interpretation throughout the federal legislative policy scheme, right?
That's right.
Strong deference to Congress,
Absolutely.
the president
Yes.
in deferring on immigration policy judgments.
Where it rightly belongs.
So if Judge Kavanaugh were presented with a situation where President Obama, for example, was letting in aliens with no colorable claim to come here,
Right.
where would he come down?
I would expect him to vote against that. If it's not in the INA, it's not authorized.
So unless he would say the president has authority to admit an alien, he would issue an injunction to stop the admission of aliens improvidently?
Yes. Yes.
Thinks that the travel ban, any idea where he'd come down on that?
Oh, absolutely. I think he would defer to the president. The INA was clear regarding the travel ban that the president of the United States had the power to suspend the entry of any alien that might harm national interests. So it's right there, black and white. I am sure that Judge Kavanaugh would have voted with the majority who upheld the Trump travel ban.
Okay. So it's good for American workers, good for American manufacturing, safe for those of us who care about the original interpretation both of the Constitution and the laws passed by Congress.